The way in which Mr Shah and I are planning to divide up topics is that I will be dealing with issues 1 and 2, namely Regulation 28 and SAMLA Section 44, and Mr Shah will deal with issues 3 and 4, namely the relevance of and content of US law. That's a slightly different distribution from that set out in our prospectus, and the subject of the call, that's the way that we will propose to proceed. There may be a short number of sweep-up points that each of us may have following the other, bearing in mind that there are certain points of detail which are specific to each of our respective clients, but obviously we will avoid any duplication.
Very good.
Can I begin then with Regulation 28? And can I start with a short overview of our position? My client, Celestial, as the call knows, is part of the Airline, which is in the business of leasing aircraft. On dates between 2005 and 2014, Airline leased 5 aircraft to Russian airlines. And those leases were supported by letters of credit, which were opened by Bank and confirmed by UniCredit in 2017 and 2020. And in the usual way, those credits gave rise to autonomous payment obligations, such that in the event of default by the Russian lessee, Celestial was entitled to make demands on UniCredit, whereupon the payment obligation fell due. And as the court knows, demands to that effect were made at the beginning of March in 2022. Now, very importantly, at the time that the aircraft were supplied to the Russian lessees and the letters of credit were opened, those two activities were perfectly lawful. So there was, at that time, no restriction on the provision of financing in connection with the supply of aircraft. In March 2022, there was a change in the law. Regulation 28 had, until that point, prohibited the supply of financing in connection with military goods, and Regulation 28 was amended to prohibit for the first time the supply of, quote, restricted goods, unquote, including civilian aircraft. And we say the purpose of Regulation 28, as amended, is obvious. It is aimed at stopping further aircraft coming into Russia from March 2022 onwards. And specifically, it is designed to stop someone extending finance which would enable or facilitate a supply of aircraft from that time. According to UniCredit, Regulation 28, when it came into force in its relevant form in March 2022, had the effect of prohibiting the discharge of the autonomous payment obligations under the LCs, notwithstanding that those obligations were undertaken at a time when it was perfectly lawful to finance a supply of aircraft to Russia. And for reasons I will develop, we submit that that plainly isn't the effect of Regulation 28. The prohibition is designed to stop someone financing a prohibited supply of aircraft. So in simple terms, in order for Regulation 28 to bite, there needs to be 1, a prohibited supply, and 2, the financing needs to be given in connection with that prohibited supply. And as I'll develop, we submit that the simple answer in this case is there never was a prohibited supply of aircraft. So with that high-level summary, can I begin, before turning to the language of the regulations, with a few remarks on the purpose and context of Regulation 28. And as to the importance of purpose and context, can I please begin by showing the court the passage in a Supreme Court case, Rossendale Hurstwood, which the court will find in the Authorities Bundle at tab 34. The relevant passage is at page 901. And it's paragraph 10, the judgment called Briggs and Law Length, to which I invite the attention of the Lordship and relationship. So it starts by saying there are numerous authoritative statements in modern case law which emphasise the central importance in interpreting any legislation of identifying its purpose. And it gives two examples which support that proposition, and in particular, that I please invite the court's attention to the remarks in the second of those passages, the Bloomsbury International. And the court will see what's said there. And it says that as with contractual construction, the notion of words having a natural meaning is not always very helpful, and certainly not as a starting point before identifying the legislative purpose and scheme. And just for completeness, there's a pithy summary of what we say is the correct approach to statutory construction in a lecture given by Lord Burroughs, which the court will find at tab 53 of the Authorities Bundle, at page 1447. And this is the passage halfway down the paragraph starting sometimes students are taught.
So what's the page?
It's 1447. I'm working from the
I know you are.
so I apologise if there's a discrepancy. So it's internal page 6.
Yeah.
Page 1447, and halfway down the paragraph starting sometimes students are taught, and Lord Burroughs says that in his view there is only one correct modern approach, that one must ascertain the meaning of the words in the light of their context and purpose of the provision. So again, we see the importance of identifying at the outset the context and purpose. And we submit in this case that the language and the purpose of Regulation 28 are fully consistent with and indeed reinforce one another. Now, the purpose of the regulations as a whole is to exert pressure on Russia to cease its invasion of Ukraine. And we say it's axiomatic that sanctions are intended to have some adverse impact which is felt by the Russian state or Russian persons. And Regulation 28 forms part of the trade sanctions under Part 5, Chapter 2 of the regulations. And that starts at tab 4, page 82. And the key purpose of the trade sanctions in Chapter 2 is to stop the supply of restricted goods or restricted technology to Russia as one of the tools used to exert pressure on Russia and degrade its military or industrial capability. So we see, in many ways, the heart and soul of this part of the regulations is Regulation 22 sub 1, where we see the export of restricted goods to or for use in Russia is prohibited. And that is the essential purpose of this part of the regulations. It's designed to stop we see a Regulation 22 that concerns the export of restricted goods, just skimming this section. Regulation 24, again, is concerned with the supply and delivery of restricted goods to Russia. Regulation 25 prohibits a person from making available restricted goods or technology to a person connected with Russia. Regulation 26 prohibits a person from transferring restricted technology to a place in Russia or a person connected with Russia, and so on. And Regulation 28 concerns the provision of financing for the supply of restricted goods or technology. And that is, we say obviously, in service of the central purpose of Chapter 2 of Part 5.
So is this right? So I just pause for a second. So you're saying that the central purpose of Chapter 2 is to prevent restricted goods or restricted technology from being provided to a person connected with Russia or for use in Russia. And
Yes.
27 and 28 back that up in relation to technical assistance and financial assistance, in essence.
Yes, indeed. So they are, if you like, spin-off or ancillary regulations, all of which are concerned to cover off the bases to ensure that from March 2022 onwards, there's a prohibition on the export or supply of restricted goods to Russia.
And when we're talking about restricted goods or restricted technology, I think the point was made yesterday. Interested to hear your comment. Is that just a sort of label? It doesn't have any meaning in and of itself. These are just labels which are attached to types of goods and types of technology.
I don't know where I want to dodge that question, but if it's convenient to your lordships, may I deal with that point when I come to the language of regulations? It is an important point, but I may first of all set up the overall purpose and then turn specific to that point. I will certainly come back to that, but it may be more convenient to do it when we turn to the language of Regulation 28. And so we say that, looking at the overall purpose of Regulation 28, the rationale is straightforward. It is designed to cut off the supply of financing by means of which to obtain restricted goods. And of course, Regulation 28, in its amended form, came into force only in March 2022. And we say the prohibition is by its nature respective. In the case of aircraft, it's designed to stop any further aircraft coming into Russia. Plainly, it can't turn back the clock in relation to aircraft which are already in Russia. And in our case, the 5 aircraft were supplied to Russian lessees.
Again, can I just pause for a second? Is that accurate as far as it is broadly stated? Aircraft by their nature come and go. That's the nature of the beast. If an aircraft happens to be in Russia carrying a cargo, I don't know. I haven't looked at the evidence as to whether the particular aircraft that we are concerned with were operating purely within Russia or were operating, taking goods to and from Russia, such that they might at some point be outside Russia, or if the lease was brought to an end, for example, might no longer be available for Russia. I just don't know enough of the background facts to understand your submission that when they're in Russia it's too late.
Well, I can see that on certain, I understand, I don't want to overstate this point, I can see on certain fact patterns, it may be that if an aircraft is supplied to a Russian airline and then it is flying around between France and Russia, say, I understand that there may be a fact pattern where comes out of Russia, the lease is terminated, and at that point, it could be said upon the termination of the lease that obviously there can be no further making available to Russia of that aircraft. But I think in broad terms, the point is the same, that from March 2022 onwards, the idea is to stop aircraft coming into Russia, and that may, or certain fact patterns include getting rid of aircraft which are already in Russia but have flown to some other jurisdiction. So I can see that. But in our case, of course, the 5 aircraft were supplied to Russian lessees long before March 2022. And were it the case, as UniCredit contends, that Regulation 28 prohibits UniCredit from discharging its autonomous payment obligations, I think it's common ground between us that would have no effect at all on the continued availability of those aircraft to Russian lessees. So as we put it in our skeleton, the regulations are designed to shut the stable door, but in this case, the horse had bolted several years earlier. And that being so, we submit that UniCredit's instruction would not in any way advance the policy of the regulations and would instead be a very surprising and odd result. And that is a consideration which we would invite the court to keep firmly in mind when considering the language of Regulation 28, to which I now like to turn. So, in terms of the language, there are 3 main points we make. First, in this case, there has never been an arrangement whose object or effect is the supply of restricted goods. In the case of each aircraft, the arrangement is the entry into the lease by which the aircraft was supplied. And in asking the question, is there an arrangement to supply restricted goods, we submit that one has to ask that question as at the point in time of entry into the arrangement. And the leases...
Sorry, there's a number of points you're making there that need to be unpacked. One is your use of the term restricted goods, but another one is that you say that the arrangement is the entry into the lease. But is it not also the continued existence of the lease, bearing in mind we have this language of making available? So that's one point, and another point which I think my Lord has already asked you about is what you're coming to, I know, is the concept of testing whether something is restricted only at the date of the lease. But there's at least those 2 points there in what you've said.
I understand it. That's very helpful. Perhaps I can start with the arrangement point.
Yes.
And so, as I think you were shown yesterday, the term arrangement is defined at Regulation 2, which is tab 4, page 69. And we see that arrangement includes any agreement, understanding, scheme, transaction, and so on. And so we say it's clear, if we look at what arrangement encompasses here, it is, if you like, a one-off event here. It is the agreement by which the supply is made available. And that, of course, is entry into the lease.
Why do you say it's one-off? I mean, why, to pick up my lady's point, I mean, an agreement can be an agreement which has continuing effect.
Yes, but of course, one has to distinguish between the making of the agreement and then the performance of the agreement, of course. And so we submit that arrangement it's not dealing. The way it's put here is arrangement, understanding, scheme, transaction. So we submit that on that language, it appears to be contemplating the act you're making, the act, if you like, by which it is the transaction by which the aircraft are made available. And that may, of course, be a 5-10 year lease, whatever it may be, but the arrangement is we submit most naturally to be understood as the entry into that lease.
Okay, but we're looking at the term arrangement in the context of 28.3, which is talking about the object or effect of an arrangement. That can't be the agreement itself. But, for example, it refers to export or supply. Those are things that happen pursuant to an agreement or under an agreement. They can't refer just to the agreement itself.
Well, we'd respectfully say that if we take the example of a lease, suppose if one's entering now into a lease to be supplying aircraft to Russia, the arrangement is the lease, and the lease has the object or effect of exporting aircraft to Russia. And so we say that's perfectly consistent with arrangement being the transaction or the lease. And we'll ask the question, what is the object or effect of that agreement? And if the object or effect of the agreement is to be supplying aircraft to Russia today, then plainly that understanding or contract or lease would fall within the scope of Regulation 28.3. Now, picking up the, as it were, definitional point, which your ladyship and your lordship have asked me about, the category of restricted goods exists because it describes the scope of a prohibition which kicks in from March 2022 onwards. So if one puts oneself back in time, in say 2020, there was no concept of restricted goods. And that's because there was no prohibition. So Regulation 28 sub 3 was simply irrelevant to a lease entered into in, say, 2020. So we say that, as I submitted earlier, we say the prohibition is by its nature prospective. It is designed to stop access to restricted goods from March 2022 onwards. And in that context, restricted goods for the purposes of Regulation 28 should be understood as meaning aircraft and the other categories of restricted goods, which are the subject of a prohibition from March 2022 onwards.
If I've understood you correctly, you're putting a lot of emphasis on the use of the word restricted as a defined term. Now, well, there's case law on the relevance of the, or otherwise of the definition. But if the definition had read, if the label had read something like specified goods, would you still be making the same submission?
I would, my lady. I don't attach any weight to the label itself.
Okay, well then I don't think I've fully understood your submission.
My submission, we can call it whatever label we want, restricted goods or specified goods, whatever it may be. That is a basket of goods. It is a description of basket of goods. And that description only comes about, that basket of goods is simply describing the scope of what is prohibited in Chapter 2 of Part 5 of the regulations. It is all about prohibition. That is the heart and soul of what this part of the regulation is concerned with. So I attach no weight to the term restricted goods of itself, but that term is used because it is describing the goods which are the subject of a prohibition as set out in this part of the regulations.
Suppose you have a lease concluded in February 2022 for delivery of aircraft after the 1st of March. So the arrangement, the one-off event, takes place at a time when the aircraft are not within the definition of restricted goods, but their supply is to be after that. What then?
Well, we would say that on the logic of the case I'm putting forward, that one has to, that arrangement is simply entry into the lease. But even on the lordship analysis, even if the arrangement was widened to be included not simply the actual agreement, but the supply itself, then obviously on our facts, that wouldn't actually matter, because of course the supply of the factual supply of the aircraft long predated.
Well, I know on your facts, but I'm testing your submission that it's all applies to, the arrangement applies to a one-off event, and if it takes place long before, then it is not caught. But what if it takes place shortly before? So the delivery of the aircraft and indeed the opening of the letter of credit don't have to take place until after the 1st of March. And as I understand your submission, you would say that is not prohibited.
Yes, that would be our submission.
So, and just to follow on the point, I mean, forget a lease for a second. Just let's assume that somebody manufactures a specified good of a type which is caught by the regulation, and the contract is entered into in February, but for delivery after the 1st of March. You say not caught because at the time the contract of sale was entered into, it wasn't a restricted good, and even though it was only for delivery after the 1st of March, that isn't caught. I mean, that would be a massive hole in the sanctions.
Well, I don't want to put all my eggs in the basket of arrangement being confined simply to the contract. I can see an alternative analysis might be that the arrangement encompasses both the actual lease combined with a factual supply, and that might be an alternative way of construing the arrangement. Certainly our primary case is that arrangement simply means the lease.
Okay, but if you take that alternative approach, then in the context of a lease, it's a continuing arrangement. And as I understand it, none of the leases were, to the extent this might be relevant, none of the leases were terminated until after the 1st of March.
So I'll come back and maybe to the termination point in a moment.
But it's not the put it this way, the contractual arrangements between the parties are not sort of fully completed once the aircraft has gone to Russia, because there's a continuing contractual arrangement under which you could say the aircraft is being made available under the terms of the lease in exchange, presumably, for payments.
In my respectful submission, one has to keep separate the question of the lease and the factual and the one-off. The one-off events, if you like, are the lease and the actual physical factual supply of the aircraft. And those one-off events, the actual export in the first place, may constitute the arrangement. As you know, my primary case is simply the lease, but I can see alternative analysis that could include the one-off export. And then there may be a 5-10 year lease, whatever it is, where the performance of that lease continues. But we would say, looking at the language of Regulation 28.3, the arrangement whose object or effect is the export or making available of restricted goods, that encompasses the one-off events of the actual physical transfer of the aircraft to Russia.
Okay.
It doesn't contemplate the performance.
Right, so your alternative case distinguishes a one-off transfer to Russia and ongoing performance.
Yes.
And just to make sure I've understood what you say about not attaching weight to the label, does that mean that for the purpose of interpreting the regulation, we could read it as if it's talked about the export of aircraft to or for use in Russia?
Well, not quite. When we say that one has to read it meaning aircraft, which are the subject of the prohibition from March 2022 onwards, because this only kicks in March 2022. And so there's a slight qualification to just any aircraft.
That is not, well, would you agree with this? That is not what the literal words say. So literally, you could read in all the things that are listed as restricted goods. There are lots of them, but let's just stick with aircraft. So literally, would you agree that you could read 28.3 as covering, in the case of 3C, directly or indirectly making ... civilian aircraft available?
Well, I said it would be capable of that.
But you don't, well, do you agree with me that that is the literal interpretation, or do you say you're adopting a different approach?
Well, we say one has to keep the purpose firmly in mind when it comes to construing Regulation 28 sub 3, and bearing in mind the purpose of this part of the regulation is to be stopping restricted goods coming into Russia, and that was a prohibition which kicked in for the first time in March 2022. Before then, it's perfectly lawful. We say that aircraft in this context are most naturally forced to be understood, bearing in mind the purpose, as aircraft which are the subject of a prohibition from March 2022. And that's because the whole scheme, the whole premise of this part of the regulations is by its nature prospective. It is concerned with looking forward, not backwards. So I'm not seeking to read words in, but we say those we say it's necessarily implicit in Regulation 28 sub 3 that is talking about aircraft which are the subject of a prohibition which only bites from March 2022.
But so assume the government is sitting there on the 1st of March saying, what do we want, or what do we want to stop? We want to stop civilian aircraft being made available for use in Russia from now. Yep. They weren't previously prohibited, but things have got worse. We want from now to stop civilian aircraft being made available for use in Russia. They see a contract which is previously being entered into in relation to the supply of civilian aircraft, whether it's by sale or lease, which is to take effect on and from the 2nd of March. Why shouldn't that fall within their aim or purpose of stopping civilian aircraft being made available after the 1st of March for use in Russia, even though the contract was entered into earlier? I mean, forget the financing for a second. If it's just the supplier you're talking to, the supplier is one who, by definition, may have will have entered into a perfectly lawful agreement. But the aim of sanctions is to say, no, we must stop that being given effect, because the effect of it is, object or effect, the effect of it is that a civilian aircraft will go to Russia after the 1st of March. If you don't catch that, there's a massive hole in the sanctions regime, isn't there?
Well, I think it comes back to the exchange we had earlier, where although my primary case is that arrangements confined to the lease, I do accept that there is my alternative case is that arrangement would be both the lease and the actual active supply, which I think would accommodate the situation which certainly on my alternative case, I certainly recognise that that would be caused by an arrangement, because arrangement would encompass both the lease and the supply itself.
But if your primary case is right and arrangement is a one-off event, and you made that point by reference to the language of the definition, then that destroys the possibility of your alternative case, doesn't it?
It does.
And therefore leaves what my lord calls the massive hole.
Indeed, I appreciate that, and that's why I fall back on the alternative case. And so, just stepping back and putting the point perhaps in a slightly different way, we say that Regulation 28 is aimed at catching financing which is connected with a prohibited supply of aircraft. But in our case, the financing has nothing to do with a prohibited supply of aircraft. The financing is linked instead to an entirely lawful supply of aircraft. So, looking at the language of Regulation 28,
sorry, you made that assertion, but I'm sorry to interrupt you, but I'm going to test it again. Let's assume, for simplicity's sake, that the lease payments are made on a per journey or per DM basis. And I don't think we've actually looked at the lease, in terms of the lease, in terms of how the payments are made, but let's just assume a case in which the aircraft is based, let's say, at Luton or Stansted or some other sort of place that has cargo facilities. And the lease says, well, every time you fly to Russia and back, there's a payment to be made. And your letter of credit backs up that payment. Well, why do you say that financing would not be connected with a prohibited supply?
Well, financing I have in mind, when I say the financing, I mean the payment under the letter of credit in our case. So I obviously, if the payments under the lease,
your LOCs back up their security, aren't they? I mean, they're security. They're given us. I know you say I fully understand the concept of an independent obligation, but we know that they are security for the payment of rental by the lessee.
That's correct in terms of economic terms, if you like. I'll address you in a moment on the importance of the time of the payment obligation, but I accept that as an economic or factual matter, that is correct. But we come back to my overarching submission that the arrangement was perfectly lawful at the time it was entered into. That is my core submission.
It is, but you then made the subsequent, and I was trying to pick up the subsequent submission. So I think, I was trying desperately to write it down fast enough, but I thought your submission was not only that it was lawful when entered into, but it was continued to be payment in relation to lawful supply. Did I mishear that?
That is the crux of my submission. We say that Regulation 28 is fundamentally concerned with catching financing to do with a prohibited supply of aircraft. But in our case, there never was any prohibited supply of aircraft, because all this happened before March 2022. And therefore, the provision of funds under the letter of credit, that is, if it's in connection at all with any supply of aircraft, it's in provision with an entirely lawful supply of aircraft, because it's in connection with supplies which happened long before March 2022. So we say that if there is a connection between the financing and the supply of aircraft, the financing is connected to an entirely lawful supply of aircraft. So we say that means that, one, there is no arrangement for the supply of restricted goods, and two, in any event, the financing was not provided in connection with the supply of restricted goods. So that's the first point we make. The second point is this. We submit that the financing which Regulation 28 is intended to catch is financing provided for the purpose of enabling or facilitating a supply of aircraft. So, as we saw earlier, the purpose of Regulation 28 is to cut off financing by means of which to obtain a supply of aircraft. So the only reason Regulation 28 is prohibiting financing is because that financing is a means to an end of supplying restricted goods. So we say the expression in pursuance of or in connection with, in this context, connotes, at least in broad terms, some type of causal nexus between the provision of the financing and the supply of the aircraft. But in our case, come March 2022, one is concerned simply with the discharge of an autonomous payment obligation, which follows many years on from the actual supply of aircraft. And the discharge of the autonomous payment obligation cannot, we say, at least for the facts of this case, have had any effect on the supply of aircraft to Russia. So we say that simply isn't the situation which Regulation 28 is intended to catch. And so far as the autonomy principle is concerned, well, we don't rely upon the autonomy principle as the be-all and the end-all. But in circumstances where the credit is by its nature entirely separate from the underlying contract, we say that the discharge of an autonomous payment obligation cannot be regarded as, quote, in connection with any supply of restricted goods. So that's the second point. The third point.
You can only, the payment could only, the drawing on the letter of credit by demand had to follow a failure by the lessee to comply with its obligations under the lease. I mean, that's explicit in the terms of the demand.
Well, an asserted failure, not necessarily an actual failure, hence the autonomy.
Indeed, yes.
Yes, but it there had to be an asserted failure to comply. So there had to be a failure by the lessee to make one of the scheduled lease payments.
Well, or otherwise presumably failed to comply. Some other
Yes, it could be. I think it's any default. But, yes.
What I'm struggling with is to in my head, I have that the lease. We haven't looked at the aircraft lease, I don't think. But presumably it's done on a, I don't know, is it quarterly in advance or some other sort of basis for continued use?
I'm afraid I don't know offhand actually what the payment schedule is under the specific lease.
My lords, I'll be able to assist you a little bit on that.
I'll try and restrain myself until then.
But the underlying point is that to trigger, there must at least be an assertion of a failure to perform the lease.
Yes, so that's obviously the condition which engages the payment obligation. That's the condition which needs to be fulfilled before demand can be made. But of course, the payment obligation is an entirely autonomous one.
No, well, I understand the payment obligation is an autonomous one. What I was trying to do, and I'll wait till we've shown it, but if, for example, all the supply of aircraft for use in Russia had taken place under the lease and the payments were being made subsequently, such that there was a complete disconnect between what was actually going on with the plane and the obligation to pay, I would understand your submission had much more force, because you would be saying the payment obligation is both legally and factually disconnected. The supply has taken place. It can't change anything. It can't. The stopping of the payment couldn't serve to stop the aeroplane being used in Russia. If, however, the lease payments are coterminous with, contemporaneous with the continued use of the aeroplane in Russia, then it's a more difficult case, I think, for you to put on.
Well, respectfully, we suggest that one has to. Well, we're not concerned here with payments under the lease by the Russian lessee. That the provision of financing we're concerned with is obviously the funds for payment under the letters of credit. So it may or may not be the case that if the Russian lessees default on their payment obligations on the leases, that may have an effect on the continued supply of aircraft to Russia. I entirely appreciate that, but that's not what we're concerned with. We're concerned with a separate obligation, which is payment under the letters of credit, and whether or not payment under the letter of credit is made won't, we submit from any view, have any factual connection or bearing upon the continued supply of aircraft to Russia. So, of course, it may be triggered by a default by the Russian lessee, but the lease payments are completely separate from the provision of funds which we're concerned with in this case, which are simply payment under the LCs. The third point is that the leases were terminated before the debt under the LCs fell payable. And my Lord Justice Snowden asked yesterday about the chronology concerning termination. That is recorded in the judgment, so the call bundle.
It's not a complete record, though. It seems to vary between, unless you can help out there, it seems to vary between leases, between the parties.
Can I, well, I will if I may confine myself to celestial position and allow Mr. Charge to develop constitutional position.
Indeed.
Tread on his toes.
Right.
But certainly so far as celestial position is concerned, if I can ask the court to turn to page 204, tab 15, page 204. It's powers 12 to 16. And we see in paragraph 12 that the demands were made on the 2nd and the 4th of March. So that's paragraphs 12 and 13. And we see in paragraph 16 that the leases were terminated on the 3rd and 4th of March. And there's actually more detail about this, just for the court's note, in Mr. Smith's statement. You don't need to turn it up, but just for your note, it's supplemental under tab 1, page 5, paragraphs 15 and 25, where there's further detail set out about the relevant termination. But in simple terms, we've got demands made on the 2nd and 4th of March. The leases are terminated on the 3rd and 4th of March. And then at paragraph 15, we see that the judge held that the debt fell payable on the 11th or the latest, the 14th of
What was the reason for termination of the leases?
May I take instructions on that?
But paragraph 16 reads as though it is the imposition of sanctions that gave rise to
I'm-
the impression given.
Yes, that's certainly my understanding. I don't, whether there was a separate payment default, I actually don't know what happened. It obviously hasn't been an issue at this point. But it's certainly recorded, as my lady indicated, following the imposition of sanctions following the conflict. And I'll see if I can take, if we can provide further information about that. Now, our primary position is that whether or not the leases were terminated doesn't actually matter, because on any view, the aircraft were never restricted goods. But in any event, if the court were to be against me on my primary submission, the leases were terminated by the time that the debt fell payable. And so, on that basis, payment, we say, cannot be regarded as in pursuance of or in connection with any relevant arrangement, because that arrangement was a thing of the past.
So is this right? You say the provision of fund, try and put it in terms of the language of 28.3. The prohibition is on the direct or indirect provision of funds, I think is what's been focused on thus far. And you're saying that means payment. And you're saying that it's clearly the provision of payment, which is the object of 28.3, took place or was due to take place contractually, pursuant to an arrangement which at the time of payment no longer had the object or effect of the supply of aircraft to Russia.
Well, yes.
Or was it that there was no longer an arrangement?
Well, it can be put, I think, in either terms. I
Yeah,
think the way I
okay.
put it is probably the latter, i.e. that there was no arrangement at that point. The arrangement was a thing of the past. It was dead in the water at that point. But I think I think your lordship, I think the substance of the point is the same.
Yeah. So you say that you must look at what 28.3 is actually stopping, and it's the provision of funds. And that's why you concentrated it on the payment obligation, the timing of the payment obligation.
Yes,
Yeah.
It doesn't sit very obviously with the autonomy principle, does it? So, I mean, as discussed yesterday, the payer wouldn't even necessarily know, I don't think did know, in this case, whether the leases were terminated. How do you address that point?
well, as I say, my primary case is that this is a icing on the cake point, the termination point. On my primary case, termination is actually irrelevant. So it's really only if the court is against me on my primary case that we come to look at arrangement, and that we come to look at the termination analysis. So I think ex hypothesi, your leadership would be against me on the autonomy point, which is part of the basis of my primary case. And if the court is with me on my primary case, then obviously the termination point will be for decision. But I appreciate there is something of a tension. On the one hand, I'm saying in terms of my primary case that we don't even need to look at the state of affairs for the underlying lease, whether its existence or not, partly because of the autonomy principle. That's my primary case. But if you're against me on that, then we say, on any view, however broadly the arrangement might prove to be construed, once the lease is terminated, they can't possibly be an arrangement in connection with or pursuant to funds.
See, this is focuses attention on something I picked up yesterday, and I appreciate your assistance on as well, which is it talks about an arrangement whose object or effect is, not is or was. And on one view, the arrangement, the object or effect of the arrangement, namely the making of the lease, was at one point the making available of airplanes for use in Russia. Indeed, on the 1st of March, it still was extant and had that purpose. If it's on this latter point, I understand your primary argument is that actually at the time it was entered into, it didn't have that purpose because they weren't within the scope of these regulations. So in a sense, they were out, then they came in. The alternative way you're putting it is to say, well, no, you focus on the payment, and at the time of the payment obligation, it falls to be performed. There is no longer an arrangement whose object or effect is, because there isn't. It doesn't exist. Or it no longer has that object or effect. It has ceased to be.
Well, yes, I respectfully adopt that analysis.
Well, I'm just trying to, I'm trying, in fact, to just encapsulate in my own mind, speaking it out, your case.
Yes, but I think it's fair to say that you express pithily and accurately the case I'm putting forward. Yes, so we would say that once it's terminated, once the lease is terminated, then that isn't, then payment, the word is obviously focused on the present tense, and that there is not, and payment is not in connection with an arrangement whose effect is, in the present tense, the supply of goods, because it's been terminated.
Right.
That completes what I wanted to say about Regulation 28. May I then turn to SAMLA Section 44?
Yep.
And this, of course, arises on the premise that Regulation 28 did not apply. And as the court knows, UniCredit contends on that basis that it's excused from paying costs and interest by reason of Section 44. Now, there are two issues under this heading. The first is a factual question. Did UniCredit hold a reasonable belief that Regulation 28 prevented payment? And second, if so, does Section 44 have the effect of excusing it from paying interest and costs? So can I start with the first of those questions? Did UniCredit hold a reasonable belief that Regulation 28 prevented payment? We say the evidence does not establish that UniCredit held a positive belief that Regulation 28 prevented it from paying. And even if it did, we say that belief was not a reasonable one. Now, the question of what belief was held and whether such a belief was a reasonable one involve overlap so far as the evidence is concerned. So I will start, if I may, with the evidence on belief, and then make submissions in relation to both the question of belief and reasonableness. And you were showing some of this evidence by Mr Quest yesterday, but it is important to spend a bit more time on the evidence. And so could I please ask the court to take up the supplemental tab 3. Now, just by way of as evidence from 2 UniCredit employees, there's Ms Foster, who's saying that we're looking at now, and she is head of the compliance unit, and there's Mr Marsman, who's head of the UK business unit, which we see referred to as Global Transaction Banking, or GTB. So if I could please ask the court to start at page 51, paragraph 15 of Ms Foster's statement. she says it's important to note that the financial crime compliance team, this is her team, are not decision makers. Rather, we provide advice and recommendations to the frontline business. As we'll come to see, the frontline business is the GTB business, which Mr. Marsden. And then over the page at paragraph 19, at the very bottom of that page, going over to page 53, Ms. Foster explains that there were differing opinions as between the financial crime compliance team and GTB UK business, that's Mr. Marsden's team. And she explains that her preliminary view was that sanctions might prevent us from paying under the LCs. Paragraph 20, she explains that UniCredit sought external legal advice. There's nothing said about the content of the advice, there's no waiver of privilege. And paragraph 23, she explains that the analysis had not concluded by around the 7th of March, but she goes on to say, my team, so this is the sanctions team in contradistinction to Mr. Marsden's GTB team, thought it was likely that regulation 28 would prevent payments. And 5 or 6 lines down, she refers to UniCredit's low appetite for sanctioned risks. And she goes on to say that Ms. Gibbons' statement at paragraph 33 accurately explains the view she held. We'll come to that in a moment. And it's important to note that she says nothing here about the view held by the GTB team or by Mr. Marsden. So if we then turn to Mr. Marsden's statement, this is at tab 4. Just by way of reminder, based upon Ms. Foster's statement of paragraph 15, Mr. Marsden is the decision maker in this context. And at paragraph 16, he explains that the financial sanctions compliance team, i.e. Ms. Foster's team, came to the conclusion that the bank would be in breach of UK sanctions in case the bank pays the beneficiary, i.e. Celestial, and receives funds from the issuing bank. And that "and" is very important. There's obviously a linkage between payment to Celestial and receipt by Spare Bank. And that's the way he's putting his evidence in paragraph 16. So at paragraph 17, he says, my managers and I challenge the financial sanctions team. And that's, of course, consistent with the evidence we saw from Ms. Foster earlier, explaining the differing opinions. So, plainly, looking at paragraph 17, it's to be inferred that at this point in time, he did not believe that regulation 28 applied, otherwise he wouldn't be challenging the view put forward by Ms. Foster.
Sorry, can I just say, you said at the outset of referring to a statement that Mr. Marsden was the decision maker. That's not quite what is said in Ms. Foster's statement. She just says, we are not decision makers, we provide advice and recommendations to the frontline business. It's not saying Mr. Marsden, as opposed to the people he clearly escalated this to.
Yes, I don't want to overstate that. The point I take out of paragraph 15 is that on any view, Ms. Foster isn't the decision.
Understood, but what you're taking us to now is what happens when there's this discussion that leads to, it goes to more senior management, isn't it?
I mean, his evidence at paragraph 18 is that it's senior management, unspecified.
Yes, well, his view there is that he doesn't actually identify a belief held on anyone's part in paragraph 18. He explains that the financial sanctions team confirmed their previous opinion, leading to the final conclusion that we would in fact be in breach of sanctions. And importantly, again, there's a linkage here if we pay the beneficiary and accept funds from the issuing bank.
Well, it's got the and point, but isn't that evidence of a final, final conclusion that we would be in breach, which sounds like a belief. As I say, you've got the and point, but why should the judge not be entitled to accept that as evidence that there was such a belief?
Well, he says at the end, my managers and I then had no option to pay, by which he means we couldn't. I assume that's what he means.
Well, I assume that is what he means. He's not saying that his managers or he had an affirmative belief that Regulation 28 did in fact apply. But there was, of course, reference made to the low appetite of sanctions risk. And essentially, what I submit, he's saying in paragraph 18, the gist of it is essentially the compliance team, they told us that we couldn't pay, and who were we to be gainsaying the view put forward by the compliance?
No, it doesn't say that. It says precisely the opposite. It says we challenged their view, and it went upstairs. And what came back from upstairs was a final conclusion that we would in fact be in breach. And I would read my managers and I then had no option to pay as meaning they were told not to. So he wasn't the decision maker, he was told not to pay.
Well, the only point I make is that there is no statement of a belief when the part of any identified individual, paragraph 18, as to setting out that Regulation 28 would in fact apply. So we saw reference made to the low appetite for sanctions risk in Ms Foster's statement, and one can foresee a situation where there is uncertainty around this question on the part of senior management and the decision makers, and they take a precautionary risk-averse approach, where no one actually holds an affirmative belief that Regulation 28 applies, but taking a risk-averse approach in light of the low appetite for sanctions risk, which Ms Foster's evidence is the approach taken, one can easily foresee a situation where they're coming to the view, let's not risk it just in case. That's utterly different from having an affirmative belief that the regulation did in fact apply. Then we've got Ms Gibbons' statement at, this is at tab 2 of the bundle. And can I just show you the court what said at paragraph 33, page 31. And what's said here, 3 lines down, is that UniCredit was concerned that payment under the LCs would contravene the provisions of Regulation 28. And then there are certain matters set out which are said to support that concern. I'll come back to those in due course. And it's important to note that it's only Ms Foster who, as it were, signs up to what is said in Ms Gibbons' statement. Mr Marsden says nothing about the facts at paragraph 33. But it is, of course, a concern. We see the word concern repeated at paragraph 34. And then, so far as the licence applications are concerned, I don't think we need to go into these.
Yes, I mean, it does, the preface to 33.1 and 33.2 say UniCredit believe.
Yes, but again, only a human being can believe something, obviously, and it can be an attribution question
Well,
as to whose belief is the relevant belief for the purposes of that attribution. And I'll be making submissions on that. But we say generalised assertion of UniCredit belief takes matters although she wasn't the decision maker, I think we're submitting for the purposes of attribution. It's not her belief which falls to be attributed for section 44 purposes. I don't think we need to actually turn up the licence applications. We spent some time on this yesterday. The court has the point.
Miss Given identifies in her statement, paragraph 14.1, particularly the, not by name but by description, the head of GTB UK, head of GTB operations and global head of GTB as the people in the GTB department who she describes as being responsible for carrying out UniCredit's role as confirming bank in relation for the LCs. And she says at 14 these were, that is the base where the basis for her referring to a decision having been made by UniCredit or UniCredit's understanding of a particular matter, to pick up my lady's observation.
Well, she also refers to individuals in senior management.
Yeah.
Yes, and the only point I make is that the concern she identifies in paragraph 33 that there was no identification of any particular individual who is said to hold that concern, let alone a relative legal. And then we saw in the licence application, again, we won't turn these up, but as I think the court saw yesterday, throughout the licence application, we saw the consistent linking where UniCredit was saying, please give us a licence so that we can, on the one hand, get money from spare bank, and on the other hand, pay the beneficiaries. So there was always a rolled up licence combining those two elements. And then, can I please show the court too, at supplemental bundle tab 13, page 1 through 2, there's an attendance note of, this is a meeting or a call between Oxy and UniCredit and their lawyers. And the passage I invite your attention to is page 134, paragraph 15, and JB is a Mr. Versfeld, who we understand is an in-house lawyer at UniCredit. And he's saying that, this is on the call to Oxy, that if the court were to order UniCredit to make payment to the beneficiaries and UniCredit was unable to recover those funds from spare bank due to the sanctions, UniCredit would be left out of pocket, while spare bank would be within funds. JB suggested that this was likely not the intention of the sanctions. So again, we see this is consistent with the rolled up licence application, that it appears to be overarching concern on the part of UniCredit was to be protecting their cash flow position so as not to be caught out as hidden in the middle, if you like, where it needs to make payment to Celestial, but it can't be reimbursed by spare bank. Mr. Quest took you yesterday to inter-parties correspondence at supplemental bundle tabs 29 and 30 in support of the belief. We say that is unavailing. Obviously, in inter-parties correspondence, a party is putting forward their position. You're putting your best foot forward in inter-parties correspondence. That's quite different from whether the client holds an affirmative belief in the correctness of the position being advanced. So we respectfully suggest the inter-parties emails and correspondence are not illuminating for the purposes of testing belief. So that's a survey of the evidence. I think I may make my submission.
Sorry, was that bundle tabs 29 and 30?
I think it's supplemental bundle tabs 29 and 30. So 29.
No, I think we were taking
I'm slightly curious about that submission. I mean, are you saying that what is said by a law firm on behalf of their client is of no relevance when you're considering whether the client holds a belief? Because what, lawyers never tell the truth, or they're just putting their best foot forward, or however whatever euphemism you describe. I mean, you're saying it has no bearing upon the question of belief of the client.
I'm certainly not suggesting that there's anything untruthful. I'm certainly not making any submission along those lines. I'm certainly not making any submission of lack of good faith or anything along those lines. What I am saying, this is just characteristic of any interparties correspondence, is that if a point is arguable, then obviously lawyers have a duty to be pushing forward the client's best position on that point, and will do so in interparties correspondence. But that's quite different from the question whether the client holds an affirmative belief that the position is in fact correct. The client may have no belief one way or the other as to the correctness of the position. It may simply leave it to its lawyers, and if the point is arguable, then they may simply form no belief on that question at all.
It's not. I mean, I'd certainly accept it's not determinative that a lawyer says what a lawyer says on behalf of their client in debate with another lawyer, but to say it's of no interest to the court, or it's, as I think you said, not illuminating. I mean, you just have to take it as part of the swathe of evidence, don't you, and give it such weight as you might.
Indeed, I fully accept the court can and will take it into account in the overall mix of the evidence.
I mean, if a lawyer says, in terms, my client believes X, or by inference, my client believes X in communications, I mean, that surely can be taken into account by a court in deciding whether the client did believe X. I mean,
but it's very rare that inter-parties correspondence will express a view as to the client's belief. It doesn't do so here. We look at page 181, paragraph 6. It says it appears that substance, as it appears that UniCredit pays, then it will be in breach.
Okay.
Substance, what it says. It's not purported to be a statement of the client's.
Right. That submission, I understand it. I think that's a much more, if I may say, a much more focused submission than the previous one, which was basically, look, this is just inter-parties communication by lawyers. You can just disregard it.
Well, one of the part of tab 30 we were taken to yesterday was actually an email from Mr Marsman himself.
Yes. So
where he asserts on page 195 the bundle based on the information it appears, etc., etc.
yes. Well,
You're
again.
not suggesting he's lacking good faith, are you?
Well, I'm not suggesting. I'm certainly not suggesting he's lacking good faith. What I am suggesting is that he's not saying I believe this, and that this is just part of the course in any inter-parties correspondence, and whether it comes from a lawyer, it comes from a business manager, it's an inter-parties correspondence, contemplation, litigation. It would be irrelevant to be setting out what you personally believe. You're simply setting out the position on behalf of your company or your client. And so again, we say that this cannot be read as a statement or as probative of a belief which he himself holds. In 9 times out of 10, no doubt, lawyers put forward legal arguments, and the client simply doesn't apply their mind at all to the question of whether they believe them to be correct or not. It's a matter of law for the lawyers to be dealing with. It's a very rare occurrence. The client's affirmative belief as to the correctness of a legal position will be relevant at all.
So when Mr. Marsman said in the email we were supplied with yesterday, the 7th of March, at the foot of internal page 2, there's a paragraph which says, based on the information available to us and the sanctioned position, it appears that, etc. And then over the page, if that's correct, it would be a breach of English sanctions for us to receive or make payments under letters of credit. If you're aware of any information on that analysis, please let us know as soon as possible. He's saying the court can't or shouldn't infer that that was something which he believed at the time.
Well, he's given a witness statement to the court, of course, which I took the court to earlier. It would have been the easiest thing in the world for him to have said in his witness. He said, of course, I disagreed. I'm paraphrasing it, but we saw earlier, he began disagreeing with the assessment. If he then was persuaded and he changed his affirmative state of belief, it would have been the easiest thing in the world for him to say, and Miss Foster or whoever persuaded me of this belief, and I then thereafter held a belief along those lines. So in circumstances where the court has the benefit of a witness statement from Mr Marsman, we say that the primary focus needs to be on the evidence given in his witness statement, not an inter-parties correspondence, where completely understandably the parties are pushing their best foot forward.
So that's the evidence, and it's perhaps a question of interpretation of what precisely the various people are saying. But you have to show, don't you, that the conclusion which the judge reached was simply not rationally supportable, or language to that effect, in circumstances where there was no application to cross-examine these witnesses to draw out some of these finer points.
My lords, yes, on the cross-examination point, we're not in any way inviting the court to disbelieve any of the evidence put forward. Our point is that the evidence put forward simply is not sufficient to discharge the burden of showing they had a positive belief. So there was no need to cross-examine the witnesses, in my submission, because we weren't inviting the court to disbelieve what was said. We were simply saying they haven't put forward evidence to make good an affirmative belief. I can rattle through, I think, the headline points of my submission very quickly here. We've covered the ground, really. First of all, in terms of attribution, we say on the familiar meridian analysis that one has to identify whose stated belief is most appropriate to count as the belief of UniCredit for the purposes of section 44. And that will be the belief of the individual who is tasked with decision-making responsibility. And we say that in terms of the evidence put forward, it is Mr Marsman's belief, he's the only person who's provided a witness statement as to purporting to deal with his stated belief, who we say is a candidate for the attribution analysis. But Ms Foster basically actually isn't the decision maker, and clearly her view on that basis can't be the relevant stated belief. And we looked at Mr Marsman's evidence, I won't repeat it, but we see that he began by positively disagreeing with the view of the sanctions team that Regulation 28 applied, and he does not suggest, he does not say in his witness statement that he came to any different view. And as I mentioned earlier, we say that the fact that he says there was effectively then no option to pay is entirely consistent with the bank taking a risk-averse approach, having a low appetite towards risk, as Ms Foster says. But that's quite different from having an affirmative belief that Regulation 28 did in fact apply. And then we saw in Ms Foster's evidence that she sets out the view by reference to a concern. And as we say in our skeleton, suppose, for example, you think there's a 45% chance that Regulation 28 may apply. You are concerned that Regulation 28 may apply, but it can't be said in those circumstances that you hold a positive belief that it does apply. And we say it's entirely unsurprising that a bank may well take a conservative approach. It may well take the view that because sanctions might apply, they should err on the side of caution. And that may be perfectly understandable hold an affirmative belief that Regulation 28 does apply, they can't take the benefit of Section 44. Now, in terms of what the judge held, this is his consequential decision at court.
Sorry, you said Foster refers to a concern. Is it given?
Oh, sorry, I apologise. I meant this given.
Yes.
So it's core bundle tab 16.
Although, actually, to be fair, Miss Foster did say, I entirely share given 33.
Indeed, yes. Yes, she effectively endorses what's said in this given statement.
She says that was my state of mind at the time, I think, all
Yes,
words to that effect. Just
and so tab 16 we have the judgment, and effectively paragraph 6 to 11 set out the submissions and the evidence, and at paragraph 12 that is the sum total of the deputy judge's reasoning and analysis on this question. And you'll see what he says here. He says that I've come to the conclusion that UniCredit has established, albeit not very clearly, that it did have the relevant belief. He says it could have been approachable clearly by a simple statement to that effect. I take the view the combination of statements, in fact, forward does indeed establish this fact. So that is the totality of the judge's analysis on this question. And we say with respect to the deputy judge, he hasn't actually engaged in the exercise of identifying what specific bit of the evidence has led to that conclusion. So one searches in vain to be finding where is the specific evidence which founds his conclusion that there was an affirmative belief. There was, of course, no cross-examination, so your lordships, your ladyship, were obviously in as good a position as the deputy judge to be deciding this question. And we say, based upon the evidence which I've shown you, we do submit that the deputy judge was plainly wrong to come to the conclusion that UniCredit had discharged its burden to be showing that an affirmative belief was held. So that's the belief question. In terms of the reasonableness of belief, if the court's against me on the prior belief question, we say that the deputy judge was correct to conclude that the belief held was not a reasonable one. And the burden is, of course, on UniCredit as the party seeking to invoke Section 44 to establish that its mistaken belief was a reasonable one. And
Is burden of persuasion likely to matter? I mean, won't we just come to a view one way or the other?
I suspect that's right. I simply clarify what the burden is on UniCredit. I'm sure that the lordship's right about that.
Yeah. Okay.
So the starting point for the a relevant factor so far as the deputy judge was concerned is that in his main judgment, at paragraph 126, he came to the quote clear conclusion unquote that Regulation 28 did not apply. And the lordship, your ladyship, may or may not share that view. We will discover that in due course. But that, of course, is the starting point for the deputy judge's analysis. Certainly in my submission, we say that the belief was manifestly wrong and objectively was not a reasonable one. Now there was an exchange yesterday with Mr Quest and the court, which effectively was along the lines as to whether showing the word is relevant for the purposes of holding a reasonable belief. And we say that the process by which UniCredit came to hold its mistaken belief is highly relevant to the question whether that belief was a reasonable one. Let's take a simple example. Suppose there's a maths exam which two students are sitting, and the two students come up with the same answer, which is wrong. But one student has approached the question in the right way and set out their workings, but has taken a minor misstep along the way. And the other student, who happens to have got the same answer, has simply guessed at the results, or has not shown any workings, or has adopted fundamentally the wrong starting point. While both produced the same answer, in the first case, it can fairly be said that the mistaken view was a reasonable one, but that couldn't be said in the second case. So we say that the process by which one reaches a mistaken view is highly relevant to an assessment as to the reasonableness of that view.
I mean, I don't want to get too much into the horrors of maths exams and the like from childhood, but can I just question that? I mean, if you don't explain how you got to a particular view, it might it not, have some bearing upon the court's assessment as to whether, in fact, it was your view or not at the time. But the question of whether the view is reasonable surely just depends objectively upon the result. I mean, if, for example, to borrow from an area that I'm more familiar with, perhaps you take the concept of director's duties. You ask, did the director genuinely believe what he was doing was in the best interest of the company? And was it reasonable? Is often said to be irrelevant, save to indicate that if a view was so unreasonable that you assume it couldn't be held, it would go to the question of whether the belief was genuinely held or not. I mean, those are rather more sort of pertinent sort of questions than going back to sort of maths exams, aren't they?
Well, it might be an illuminating analogy.
But I mean, the point is, in a maths exam, processes and workings, as we all know or recall, is highly relevant. Here, the test is, was the belief reasonable? It's not more than that.
But we respectfully say that in order to answer that question, one can't shut one's eyes from the way in which they came to form that belief. And here, fundamental submissions, their belief was based on a confusion, as we saw in the licence applications and Mr Marsman's evidence and the attendance notes. There was a constant interlinkage between the spare bank payment obligation and the payment obligation to UniCredit, to Celestial. And we said that is a fundamental confusion. So if they did hold the belief, we infer, we invite the court to infer, that a major factor which led them to that view was this interlinkage between the payment obligations, and that entirely vitiates any reasonableness of that view held. So in circumstances where the view is based upon a fundamental misapprehension, we say that is an important pointer against the reasonableness of that view. Now,
but again, just to test it, if somebody fully understands the autonomy of the payment obligation under the letter of credit, and forms the view that absent a license application, it would be prohibited. They might, in the course of trying to make an argument to the licensing authority, link it with the question of whether they could receive payment from Spurbank in order to, as it were, get the sympathy of the licensing authorities to just to point out that they would, as they did in fact, would be out of pocket if one license was needed and the other one one license granted and the other one not granted, for example. I'm struggling to understand exactly how you do tie the way they put the license forward with, you say, the absence of any reasonable view about the payment under the LC.
Well, I don't want to go back to it unless it was a 6, but looking at Mr. Marston's first witness statement, the substance of it is essentially saying he was told by the financial sanctions team that if Spare Bank were to pay and we were to pay Celestial, then we'd be in breach of Aviation 28, I'm paraphrasing, but that's the gist of what is said. So it appears the foundation of the belief he is putting forward is premised upon this interlinkage, which is a confusion in my respect.
Well, it's paragraph 16, isn't it, of his witness statement I think you're referring to, which makes that linkage.
Yes.
But then he goes on in the second sentence of 16 to say an application for a licence from the UK regulator was therefore discussed and recommended to receive explicit approval to process the demands by Celestial, which is solely referring to the payment under the LC.
Yes, the court should also be aware that Mr. Marston's second witness statement, just to make the court aware of this, this is paragraph, this is page 78, the second statement. He has given further evidence that, as I set out in Marston 1, UniCredit's understanding is that it couldn't make payment to the claimant, nor could it receive payment from Spare Bank. And he's obviously seeking to paraphrase what is said in his first statement. The first statement really creates much of a clear linkage between those two. But it appears to be something of a gloss put on that in his second statement.
Well, going back to the previous question of belief, why isn't that evidence of belief? I mean, you'd have to draw a distinction between understanding and belief, which seems pretty fine.
Well, it is purporting to be no more than a summary of the evidence given in his first witness statement. So what we respectfully say it's not purporting to add to what is in his first statement. It is purporting simply to summarise what's said in his first statement. And that may be an accurate or inaccurate summary. But we say the sanction needs to be given, I think it was 6 months later, something like that. The second statement was produced. And we say for the purpose of testing belief, this is first statement, which sets out comprehensively his state of belief.
Right.
And so we submit that the deputy judge was fully entitled to reach the evaluative assessment which he made in concluding at paragraph 16 that the belief held was not a reasonable one. And it's of note that at paragraph 16 of his consequential decision, the deputy judge's analysis focused in particular on the fact that it should have been clear that the obligation to pay the claimants was a wholly independent obligation owed to the claimants and did not in any way depend upon the receipt of funds from Spare Bank. So the core of the deputy judge's evaluation was this confused understanding with the interlinking payments. And we respectfully suggest that the deputy judge has recorded the substance of his analysis. We respectfully invite the court to be very slow to interfere with that evaluative assessment made by the deputy judge.
Why haven't they shown their workings? I mean, they do, don't they, in the RPC letter of 11th of March, and in the emails we've looked at. I mean, I appreciate you say those workings are wrong and get nil point, but they've said what their case is and why they say it, in much the same way as Mr Quest has submitted it to us.
Yes, well, in particular, it's this given statement of paragraph 33, which this is supplementary bundle tab 2, page 31, which I'm sure Mr Quest will say is the fullest exposition of the workings. At 33.1, we see the point is made that the goods were restricted goods, and we say that ignores the fact that the letters of credit were entered into before Regulation 28 came into force, so there's simply no consideration of that point. And we say at 33.2, the points take no account of the autonomous payment obligation. So I accept.
So it's not they haven't shown their workings point. It's just that their workings, like the maths exam, are wrong.
Well, not quite, because of course, on my case, it's Mr Marsman's belief, which is the relevant belief, and Ms Foster's evidence, Ms Gibbons' evidence, doesn't actually link to Mr Marsman's stated belief. And so it can't be inferred that the concerns which are articulated at Ms Gibbons' statement of paragraph 33 actually record the stated belief held by Mr Marsman. It would have been the easiest thing in the world for Mr Marsman to say that in his witness statement were that the case, and he hasn't done so.
Right. Okay.
So, can I then turn to the effect of Samuel section 44? So, if contrary to my submissions, the court were to conclude that UniCredit held a reasonable belief that Regulation 28 applied, the next question is whether the effect is to excuse UniCredit from paying costs and interest. And we say that section 44 is to be interpreted with its purpose firmly in mind. And to that end, can I please invite the court's attention to the explanatory notes, which are in the authorities bundle, tab 5, page 131. We realise this is of second order importance, so we set in to say not still by it, but we do say it's actually starting point. And we see in the final sentence under section 44 that the provision aims to protect people from any adverse results generated by compliance, for example, a breach of a contract to supply goods that are prohibited from export by sanctions. Now we submit that the purpose of section 44.
Just pausing there, it uses the expression person who may be liable to civil proceedings is not liable. At some point, I hope you're going to address the significance of the use of the expression liable to proceedings as opposed to liable in proceedings.
I will, if I may, I will come to that in a few minutes.
Okay.
It's certainly a point I will come to. We say...
You're relying on the sentence that refers to adverse results, but the sentence itself is not accurate because it talks about protect people from adverse results generated by compliance, and the point is the sanctions didn't actually bite.
Well, we would interpret that as meaning generated by an act seeking to comply, but it obviously isn't put as accurate as it might. Can I just give your Lordship's leadership just an overview of our position on section 44? we submit that its purpose is to protect a party in the position of UniCredit from being worse off as a result of its mistaken belief that sanctions applied. And Section 44 protects against a liability, quote, in respect of the Act, unquote, which in the absence of the section, UniCredit would otherwise have. And I will be coming to the not liable to point in due course. But this is just a summary of our position. Now, the relevant Act is the non-payment under the LCs resulting from UniCredit's mistaken belief in regulation. Therefore, Section 44, we say, protects UniCredit from liability, quote, in respect of, unquote, its non-payment brought about by its mistaken belief that Regulation 28 applied. And we say, I'll be developing this in due course, that is intended to cover, in substance, a new liability caused by the mistaken belief, as opposed to a liability in respect of the underlying debt obligation. I'll be developing this point in a moment. So to take a simple case, suppose that a seller contracts to sell goods. The seller mistakenly, reasonably believe that sanctions prevent it from delivering those goods. And the buyer then goes into the market to buy goods at a higher price, and the buyer sees the seller for the increased cost with a consequential loss. That, we say, would be a paradigm case in which Section 44 would protect the seller from a damages claim. The buyer is suing the seller in respect of a liability which arises as a result of the seller's mistaken belief that sanctions prevented it from performing the contract. Now, where Section 44 is engaged, we say that it provides a defence to liability which would otherwise arise. UniCredit contends that Section 44 precludes the bringing of proceedings for a claim to recover money, though on its case it doesn't stop the declaration claim being made. So on UniCredit's case, Section 44 operates as a partial immunity from suit. Now we say that isn't the effect of Section 44. The wording "not liable to any civil proceedings" has parallels, we would respectfully suggest, to the language used in the Limitation Act, that an action, quote, shall not be brought, unquote, after the expiry of the relevant limitation period. And in both cases, the statute provides a defence which may be raised, but does not prevent the actual bringing of proceedings. Now, UniCredit, on its interpretation, says that it would remain open to Celestial to bring a claim for declaratory relief. But UniCredit has identified no coherent basis for distinguishing between a declaration claim, which on its case would be allowed, and a damages or debt claim, which on its case would not be allowed. Both are equally forms of civil proceedings. The declaration is simply a form of relief. And I'll say more about the ex parte Wardron case in a moment, but the key point is that, as your lordships indicated yesterday in your exchanges with Mr Quest, they were concerned with judicial review proceedings, which are obviously fundamentally different from civil proceedings against a private person. The ex parte Wardron is not authority for the proposition that in a private law claim, a declaration falls outside the scope of civil proceedings.
But, Mr Mr Quest may just have sold himself short on that.
Well, let me tell you why he needs to make that concession. Let's assume that a declaration, let's assume that I'm right, and a declaration would not be exempt on Mr Quest's analysis. The position one then gets to is that section 44 would apply as Mr Quest would have it, on the footing that UniCredit held an erroneous but reasonably held view that the regulations prevented it from performing its obligations. And so UniCredit is saying that because we held a mistaken but reasonable view that regulation 28 applied, Celestial could not have brought any form of civil proceedings against it. And we say that would be an utterly bizarre conclusion. And we ask, how else could UniCredit be disabused of its erroneous view if it were not for a court decision on the point? So the consequence of UniCredit's interpretation, assuming that the declaration isn't carved out, is that a party in its position may act in breach of its contractual obligations on the basis that it misunderstands the UK regulations. And the innocent party, i.e. my client, is unable to bring any form of proceedings to disabuse the defaulting party from its erroneously held view. And we say that would be an utterly bizarre conclusion. And to create an immunity from suit, which of course is effectively what UniCredit is suggesting, would amount to a fundamental intrusion on the right of access to the court. That, of course, is a fundamental common law right, and that would require clear and unambiguous language. Now, in its evidence in response to the claim before the Deputy Judge, UniCredit, certainly so far as I'm aware, I stand to be corrected, but certainly as I understand it, at no time did it suggest, before we got to the main hearing, that the proceedings were not properly constituted for the purposes of section 44. It was never suggested there was some eliminate immunity from suit. And as I mentioned, certainly so far as I understand, that point simply wasn't raised before the Deputy Judge at the main hearing. Now, it is true that similar language to section 44 is used in the Mental Health Act 1983, and this is the subject of the ex parte Waltron case, which Mr Quest took you to. And essentially, in that case, it operated as a procedural bar which stopped patient section under the Mental Health Act from bringing claims against the doctor, but the court said that a judicial review was warranted. And needless to say, the context could scarcely be more distant from this case. The language used in section 139 of the Mental Health Act needs to be read in light of its particular context. As I think the court pointed out yesterday, there was also a subsection 2 in the language of section 139, which means that it's not on all fours with this case. Now, can I just show your lordships and your ladyship a case? This is at tab 22 of the authorities fund. This is ex parte UIN number 2. And this case concerned, in simple terms, it concerned, you'll see page 617, there is the Prosecution Offences Act 1955, which is essentially legislation to be restraining vexatious litigants from proceedings, and the language used in that legislation was similar to the language used in the ex parte Waldron case. And essentially what the applicant was saying is that, well, in ex parte Waldron, JR proceedings were permissible, and JR proceedings should similarly be permissible for these purposes. And that was rejected by the court. And just the passage I want to invite the court's attention to, if I may, is at page 619. And this is at letter C, where the court observes the background object of section 139 of the 1983 Act, section 42 of the 1981 Act, are, however, so very different that we see no reason to conclude that Parliament intended the same result to follow in each case. We say that is important. So I don't shy away from the fact the language used in section 44 is strikingly similar to the language used in the Mental Health Act. But we say context and purpose are all important here. And we say it cannot possibly be the case that section 44 can be interpreted as creating an immunity from suit. That would be a bizarre analysis and be a fundamental intrusion on my client's right to access the courts for the reasons I've stated. So once one clears that out of the way, that it can't be an immunity from suit, we say that, as with the Limitation Act, it essentially provides a defence to liability which would otherwise arise. I don't shy away from the fact that the language not liable to civil proceedings is difficult language. But we say that the court's task is to interpret that language in light of its purpose and to give, and in light of that, we say the only sensible interpretation that can be accorded to section 44 is to construe it really equivalent to the Limitation Act, that it provides a defence to liability which would otherwise arise and does not create an immunity from suit.
So does it come to something like this, that, well, in the circumstances of the present case, there's nothing to stop you from suing for the amount of the credit, as you did, and the court will decide whether, in fact, Regulation 28 applies. If it concludes that it didn't apply, then there's no reason why judgment for that amount should not be given. I mean, they're obliged to pay, and the regulation doesn't say otherwise. But the effect of section 44 is simply to render them immune or not liable for any consequential damages. So if, for example, UniCredit have suffered further losses as a result of not having the money, which could be recovered under principles of remoteness and so forth, then they're not liable for that, but they are still liable to pay the money, and no reason why interest and costs shouldn't follow. Is that essentially what your position comes to?
I could sit down now.
Well, I'm not saying I accept it. I'm just trying to understand it.
That is a fair summary of our position. He's a bit of filling out.
Because we don't really need, if that's what you're saying, to go via the Mental Health Act and vexatious litigants. It's simply a point on fundamental access to justice,
yes,
not being removed by section 44.
Yes, indeed. So just on the, before I turn to interest and costs, I think it's the point which is touching on the beginning of the Lordship's question. Can I start with the question of the section?
So put it another way, even if the judge, even if the principal amounts of the credits had not been paid, suppose there'd never been a licence, on the judge's conclusion, he would have given judgment for the principal.
Yes.
And section 44 would have had nothing to do with that.
Well, that's certainly in our case. my learned friend's case, as I understand it, is that Section 44 prevented us from suing on the debt. But as I understand it, that's how my learned friend puts his case. So, my learned friend's understanding is saying that the effect of Section 44 is that my client was precluded from suing the $46 million principal sum under the LCs. And we say that's plainly wrong.
Well, I think they'd say until the position was resolved through the licensing.
Well, I'm sorry to interrupt. I'm assuming no license
Yeah.
until a position resolved by judgment is the question, i.e. the judge's decision that there is no defence under the regulation.
Yes. Yes. Yes, I think that is. Yes, it will be judgment. Yes.
Does it come down? Is there something to be said that it may come down to defining the act, or in fact the omission? Because on one view, you could say that what has been omitted to be done on this hypothesis, the reasonable belief that the omission would be what's required to comply with the regulations, is the omission to, quote, provide funds, or whatever the wording is. It's the provision of funds by payment. And so Section 44.2 would prevent civil proceedings and basically a judgment for payment, because that is the civil proceedings to which the person would, in the absence of this section, have been liable in respect of the omission. But it doesn't, even on its own terms, stop a declaration that somebody was liable, but that's as far as it goes. I mean, is that so not going anywhere near the Mental Health Act or otherwise? Is it really, do we need to focus on what the actual act and the proceedings to which you would be liable in respect of the act?
Well, yes, I think certainly our case is the act of non-payment under the LCs. That is the relevant act.
So provided your proceedings don't make you liable in respect of that act, either or that omission, in fact, to pay, and the act of non-payment, you can have proceedings which declare that you were liable.
And perhaps also cover the position under Section 44, because that, you would say, must be justiciable as well.
Yes. Well, our position is that there's an issue between the parties as to whether Section 44 bites on the enforceability of the debt, of the underlying debt obligation. And my little friends say it does, and we say that it doesn't have any effect on the enforceability of the underlying debt obligation.
You say that the liability, the pre-existing liability under the letter of credit, is not in respect of the act of non-payment. It was a pre-existing liability which existed anyway.
Precisely so. The pre-existing liability, which predates the act of non-payment, that, if you like, is the first point. And the second point is that it's a liability which UniCredit would have had irrespective of its mistaken belief. So it's not a liability brought about by the act of non-payment, still less by its mistaken belief that Regulation 28 applied. So we say that Section 44 does not suspend or otherwise affect the enforceability of Celestial's cause of action in debt to be paid $46 million in March 2022. There was an accrual of the cause of action at that point in time, and Section 44 doesn't affect that. So that's the position so far as the debt is concerned. Turning to the question of interest, the payment obligations under the LCs fell due no later than the 14th of March payment wasn't made until the 14th of October in the case of 3 ELCs, or 25th of November in the case of the other 4. And so we were kept out of our money for about 8 months. And the question is section 44 intended to displace the default position that interest is to be awarded under section 35A of the Senior Courts Act to reflect the time value of money which ought to be paid 8 months earlier. And just a couple of points were made to make under this heading. First, for the 8th month or so period during which Celestial was kept out of its money, Celestial lost the time value of that money, and UniCredit conversely enjoyed the time value of the money which it wrongly retained, for example, by self-earning interest. So there was a loss to Celestial and a corresponding gain to UniCredit. And an important part of the purpose we submit of an award of interest is, at least in approximate terms, to restore the parties to the position they would have been in had the money been paid on time. And we've made reference to the Bank Kaiser case. I think I'm conscious of time, so I may just give your lordship a note. That's at tab 19, page 550, and referred to in our skeleton at paragraph 43. And Mr. Justice Stade, who then was, refers to the purpose of an award interest, at least in part, as being to achieve restitutio in intent. Now, as I submitted, our position is that the purpose of section 44 is to protect UniCredit from adverse consequences by reason of its mistaken belief. It is not designed to put UniCredit in any better position than it would otherwise have been. So if interest were not awarded, as UniCredit contends, the effect of that is that UniCredit would gain a windfall benefit.
But you gave the sale of goods example of possible loss. Doesn't that to an extent achieve a similar objective?
Not in that it is simply about loss.
Well,
I mean, it's not.
yes, but the aim of the conversation is to put broadly to put parties in the position in which the contract is performed. So yes, I understand the distinction you're making, but it's not that straightforward.
Well, we do submit that it's not. The point I'm making is not simply a question of loss to Celestial. With the interest not being paid, the point I'm making is that UniCredit will have enjoyed itself the time value of that money.
Yeah.
And it will therefore be placed in a better position by reason of its mistaken belief on its analysis of section 44. And we respectfully suggest that it would make no sense to construe section 44 as rewarding a party for its mistaken belief as to the law. Second, as I submitted, the debt obligation accrued in March 2022 and is unaffected by section 44. And so UniCredit stood in breach of contract from March 2022 onwards in its refusal to pay. And the interest we claim arises from the power under section 35A of the Senior Courts Act to award interest from the date of breach. And we say that an award of interest under section 35A is essentially an adjunct to UniCredit's liability in respect of the accrued debt obligation. The two go hand in hand. So we respectfully suggest that one has to keep separate two buckets of liability. There's the liability in respect of the accrued obligation that is unaffected by section 44. There is then liability arising out of an act of audit compliance, such as a claim with consequential losses. And we say that an award of interest under section 35A is in the first of those categories. So for the purposes of section 44, it is a liability in respect of the underlying payment obligation as distinct from a liability in respect of an act of reported compliance. So for those reasons, we submit that it falls outside the scope of section 44, and we say that section 44 cannot be read as displacing the power to award interest as the court sees fit under section 35A. Our third and finally, on interest, the essence of UniCredit's argument is that the effect of section 44 is to replicate the position that the parties would be in if regulation 28 had in fact applied. But the court note, see UniCredit's supplemental skeleton, paragraph 16 and 24. So UniCredit say, if regulation 28 had applied, it would have been unlawful to pay the debt, and therefore no interest would be due. And second, the effect of section 44 is to replicate that position. We say with respect to that analysis is fundamentally mistaken. If regulation 28 had in fact applied, we accept that it would of course be unlawful to pay the debt, and in that situation interest would not run. And that's the type of situation the Leadwater case, which was Barnes took you to yesterday, and other of the cases referred to at the supplemental skeleton at paragraph 23 addressing. But that's not the world we're in. The world we're in is a situation where at all times it was perfectly lawful to pay the debt because regulation 28 never actually applied. And at all times, UniCredit was under an obligation to pay the debt. So that's the critical difference between those two scenarios. So we say that legal consequences which would flow in the event that regulation 28 applied, and therefore would be unlawful to pay the debt, can't just be transposed to a situation, as with our case, where at all times it was perfectly lawful to pay the debt. So those are the points on interest. I can take costs more shortly.
What's the underlying policy of section 44? I mean, is it to ensure that people, if they have a reasonable belief that the sanction regulations require them to do something or to abstain from doing it, but they shouldn't have their decision altered by a concern that if they don't, they will suffer financial consequences. So why shouldn't section 44 be read in a way that removes that risk from somebody who has a reasonable belief that they shouldn't be doing something in order to comply?
Well, as we say, the scope of it is to make sure that you're not put in a worse position than you would otherwise be in. It's the reference, the adverse consequences generated by the act of compliance set out in the explanatory notes.
So somebody in UniCredit's position thinks, okay, we have a reasonable belief, believes we aren't obliged to make payment, or if there's is it designed to cope with the doubt? I mean, by definition, it's somebody who's got it wrong, but has a reasonable belief to the contrary. But they shouldn't think, look, if we're going to be incurring a liability for interest here at a rate which is above market rates if we don't pay, so we'd better pay. And is it designed to stop people having that sort of line of thought process? It's saying to them, don't worry, if in your reasonable belief, albeit wrong, that you shouldn't be paying, you take the decision not to pay, the consequence won't be that you're exposed to a liability at a rate of interest which is designed to encourage payment, because it'd be a judgment rate, wouldn't it?
Well, of course, in our case, there's no question of punitive interest or contractual interest. It's simply the interest we're claiming is simply interest pursuant to Section 35.
Yes, but the Section 35 of the Senior Courts Act is at a rate of interest which, unless I've misunderstood it, is generally designed to encourage people to pay on judgments.
Well, it's not.
It's the pre-judgment rate.
Yes, it's the pre.
But it's generally above an interbank rate.
Yeah.
Well, I think in the commercial court, I need to remember exactly what the practice is, but certainly recent practice is 1%
base plus 1
base rate or LIBOR.
I think it's prime. I'm not sure there's an uplift, but if there is, it's prime plus 1.
Yes.
And for dollars, and it's meant to represent a commercial rate at which that kind of claimant could borrow.
Yes, and so we submit it. It's not the post judgment.
No,
the 8% post judgment that we're talking about. It's simply the standard commercial rate of interest are designed to reflect the borrowing cost. And we say on this analysis, UniCredit of course had the benefit of that time value of money for that 8-month period.
So that's not a relevant. Yeah, I think it's not a relevant consideration. It should come out in the wash neutrally, whichever way.
Yes. So
Costs.
So well, yes, on costs. So we say the position is actually plainer still in relation to costs, and we say that Section 44 does not displace the normal rule that costs follow the event. We've set out our submissions in paragraph 47 of our skeleton, but just in our summary terms, Section 44, as I submitted, protects against a liability in respect of the non-payment under the LCs. And we say that the costs liability arises not from the non-payment as such, but instead from UniCredit's decision to contest the claim. There is, if you like, a break in the chain of causation. And UniCredit could have adopted a neutral position. Instead, it chose vigorously to defend the claim, raising an ever-expanding array of arguments. We had US law, we had other arguments under Regulations 1113, which have fallen away on this appeal. So there was a vigorous attempt to actively defend the claim, and we say the costs liability is not a liability, quote, in respect of, unquote, the act of non-payment for the purposes of Section 44. Second, there are important policy reasons in my submission against giving UniCredit what would effectively be a free ride on costs. The default rule that costs follow the event is foundational to the conduct of litigation in England. It is an important aspect of facilitating access to the courts in enabling parties to vindicate their legal rights, confident that the costs of so doing will likely be reimbursed by the losing party. And it reflects basic fairness. My client had to resort to court proceedings in order to vindicate its legal right to recover the $46 million due to it. It succeeded in doing that, and fairness requires that Celestial be entitled to recover the costs associated with vindicating its rights. And we said that Parliament had intended to abrogate the basic rule that costs follow the event. One would expect that to be done using the clearest language. We said Section 44 cannot be read as ousting that rule effectively by a side wind. Thirdly, UniCredit's own case is that SAMRA Section 44 did not prevent Celestial from bringing proceedings to seek a declaration as to whether Regulation 28 applied. base they are on, it would have been permissible for us to seek a declaration claim. And that's exactly what we did. We were taking the pleading yesterday, and we did seek a declaration that Regulation 28 did not apply. And we say there was very little, if any, material increase in costs by reason of Celestial also seeking repayment of the debt as part and parcel of the same claim. So even on UniCredit's view of the world, we say it is impossible to see how Section 44 can be thought to insulate UniCredit from costs liability in respect of Celestial's claim for declaratory relief. And in any view, the lion's share of the costs incurred, in particular in relation to Regulation 28 and US law points, would be affected by Section 44. So those are the points on costs. Can I just mention, just to complete this, one point on interest, just a clarification. Just in terms of timing, the off-sea licence was granted on the 13th of October 2022, and payment under the LCs happened sometime after that, at least in the case of 4 of the LCs. It was only a month later, on the 25th of November. So even if the court were to be against me on the interest point, so far as Section 44 is concerned, so in other words, even if Section 44 did provide a defence to interest, it would cease to do so once the off-sea licence was granted on the 13th of October 2022. So therefore, on any view, interest would be payable in the period from the 13th of October 2022 to the date of payment. I know Ms Barnes made submissions about the relevance of US law. I'll leave that debate to Mr Sharp to deal with that. So as far as the UK position is concerned, then on any view, if Section 44 were to provide an interest defence, it only provides one up until the date of the licence on the 13th of October.
I'm sorry, when did you say the payments were made?
So far as my client is concerned, I stand to be corrected, but I think that the 3 of the LCs, payment was a day later. I think that's right. And 4 of the LCs, it was the 25th of November.
So we're talking about 2 weeks interest. Less.
I'm pretty sure I missed that.
So we're talking about less than 2 weeks interest.
No, 25th.
Yeah, so it's the 13th of October, the office license was granted.
25th of November, did you say?
And then it's the 25th of November, that payment was made under 4 of the LCs. So it's a point of detail, I'm sure it can be worked out in due course. I just want to make the court aware that the guillotine comes down in any view once the office license is granted.
Yes.
But Lords, unless anyone says further, there's no submissions.
Right. Okay, well, we'll hear from Mr Shah at 2 o'clock. Are you going to be able to make your submissions in time to leave Mr Quest at any rate some time to reply?
My Lord, I will. They're on the sideshow of this appeal, I think, on US law, so I'll try and keep them a little bit shorter.
Very good. 2 o'clock.